I was told we have just about 5 minutes each, so I will try and lay before you some recent developments which are aimed at highlighting some of the solutions which the courts have relied upon or which have come up in the last 1 or 2 years. You do know that there's the Supreme Court, which is at the apex of the system, and then we have 29 high courts in the country. We have, 24 high courts in the country, because some of the smaller states share a high court. And then there are about 731 district courts. So there are many, many courts in the country. Unfortunately, what I state as being some of the recent trends are restricted to the Delhi High Court, where a lot of reform, transformation, forward movement has taken place, almost revolutionary, and it is picking up in Mumbai and Calcutta and Madras, the Madras High Court, Bombay High Court, and the Calcutta High Court. But not so much as yet in the district courts. There is a lot of effort being done by training programs at the National Judicial Academies and the State Judicial Academies to try and percolate these good experiences, good practices down to the district court levels. But as it so happens that because the experience of everybody is that the Delhi High Court is such an effective court in the country, everybody tries to bring their case somehow before the Delhi High Court, because you want to avail of the best court which will provide you with the best possible relief. That is the truth. So this is one change that needs to come. Let me first talk of the biggest revolution that seems to have occurred, which is speed. One of the biggest challenges to litigation was the law's delays, that it takes too long for a case to be decided. And typically, 10 years ago, if you would ask, how long does a lawsuit take? The answer would be 5 to 10 years. Sometimes much longer. We've known cases which have extended to 20 years. Now, about 6 changes have occurred. And I need not go into those details, but I can point to 2 of them. One is the Commercial Courts Act, and one are 2 Supreme Court orders, one in a patent case in TVS versus Bajaj, where the Supreme Court indicated that it is their expectation that lawsuits will be disposed of within 4 months. And after TVS Bajaj, the Intex case, where the Supreme Court said that we expect the Delhi High Court to become a model high court for the country and for intellectual property to become a model law for all other laws, be it family law or money recovery actions or land law, any kind of law, intellectual property should become a model, the Supreme Court said in the Intex case. The effect of these 2 Supreme Court decisions and the Commercial Courts Act, along with some rules that have been framed on the original side of the High Court in 2018, have resulted in many changes. First, judges now do case management. Earlier, if the 2 plaintiff and defendant wanted to take 20 adjournments in a matter, they could do so. The judge went entirely by what the parties wanted. Today, it is not the same. The judge does case management. He will not allow you to take adjournments like that. Everything, the whole lawsuit is divided into 8 parts, and each one has a mandatory maximum term. If you do not comply with that task within that term, it normally proceeds to the next level. And you may lose your right to defend an action, your suit may be dismissed. Summary judgments can be passed. So case management, summary judgments, If witnesses cannot come, video recordings, video conferencing. Service used to take months, 8 months to 1 year to serve a defendant. Now you can do SMS service, WhatsApp service. So instantly you file a lawsuit and the defendant that very day is served with the lawsuit. These are some dramatic changes that have occurred. There are many more. I don't have the time to multiply those, but speed has been dramatically affected. If you were now to ask me how long can a lawsuit take, it can take anything from 1 to 2 years, sometimes less than 6 months, sometimes 1 day. I can give you many, many examples of cases which are finished in 1 day. That is, pharmaceutical cases where defendants come and they give an undertaking to the court that they don't intend to come out with a product. They had applied for regulatory approval, but then they don't intend to come out with the product till the patent expires. An undertaking is recorded, the plaintiff gives up his damages and costs, and the suit is decreed within 1 day. Microsoft had a whole series of actions where the average was worked out to 12 days. Within 12 days, the suit would get settled. Over the whole year, the number of cases, the average was 12 days the settlement comes with a license being taken by the defendant from the plaintiff. So speed is the biggest change. Second, internet. You rightly mentioned that in this digital world, the internet has come as a major boon, but also a bane. Also, it has created its own challenges. Opportunities, yes, but challenges too. To address this, there have been many cases of the Delhi courts, of the other courts in the country. And I'll just name the most recent of them. The Christian Louboutin matter. It's a shoe with a red sole. You may have seen pictures of it. The bottom is red. And it was a case where somebody was selling fake Christian Louboutin products on the internet, and he claimed intermediary liability as a defense, intermediary defense under Section 79 of the IT Act. And the court said not all websites can claim a Section 79 defense. Rogue websites will be stopped by the court. And the court laid down 26 tests to determine. They're quite easy, they're not complex. But tests to determine how to distinguish genuine websites from rogue websites. And that's advanced global jurisprudence forward. Not only the jurisprudence in India, but it helps any right owner who is enforcing rights on the internet. It helps distinguish between one kind and another kind of website. Take another case, a Louis Vuitton case, where the defendant made a statement in court that he does not deal in branded goods, and the goods that were recovered during the raid were not his, they were the neighbors. Immediately, when the defendant retired for lunch, and he had to sign the court statement, the plaintiff asked for a local commissioner to be appointed to go to the defendant's premises. At the premises, 36 different brands other than Louis Vuitton were found. The court gave the powers to that person to seize all. So right from Burberry, Prada, of course Louis Vuitton, and all the well-known brands were seized, brought to the court. There was a hearing. The question arose, is this contempt of court or is it perjury, giving a false statement? Perjury meant it goes to the district court and it takes about 6 months to be decided. By that time, the heat is lost and the man gets away with 1 day's imprisonment. Whereas contempt in the face of the court meant that the same judge decides it instantly, and in his anger, he gave 30 days imprisonment. It was argued, of course, that earlier that contempt in the face of the court only means throwing a shoe at the judge. But here the argument was, no, making in the face of the judge a false statement is also contempt in the face of the court. So it was a subtle point, but the result was he got 30 days imprisonment. One of our other judges, who's very forward-looking, started recording statements under section 209 of the Criminal Procedure Code. So matter was for final disposal, but it would have taken days and days, perhaps months, if it had not come up on the board. What he did was he called the directors to the court and he recorded their statements. And he found an inconsistency between the statements. And he put pressure that he will sentence all of them to imprisonment. The very next day, the matter got settled for 22 lakhs of rupees. Similarly, another matter of Bridgestone tires, the matter got settled for 36 lakhs of rupees when a person was caught lying in court. So courts are using the procedure to record the statement, bypass evidence, the general evidence and the general procedures, so as to come up with quick justice. Now, recently, there was a Pfizer writ filed before the court saying that there's this medicine which is selling in the market where the Pfizer company was unable to locate the name of the party, the address, or determine where the party is from. It said such and such name, Sri Lanka. And an investigation in Sri Lanka showed that no such party exists. The court held that the drug is illegal. The government was asked to file an affidavit on whether that particular party has licenses to sell. The government's affidavit said they don't. So the court has literally banned the sale of that drug. So, and given the plaintiff, the petitioner, Pfizer, the opportunity to bring wherever the goods are being sold to the attention of the authorities who are directed by the court to take instant action, criminal action against the offenders. Now, Delhi High Court, as I pointed out earlier, has been very flexible. The other courts are yet to pick up. There has been a little setback on the criminal law front because one of the greatest fears that a pirate has is being imprisoned. And unfortunately, there aren't too many convictions in the criminal jurisprudence. And that's something that needs to be addressed. And one more thing that needs to be addressed is the proverbial, and I think Mr. Rajiv Agarwal must have heard this 750 times, is the section 115(4) of the Trademarks Act, which says that if you find counterfeit trademark goods, you cannot straight away go and pick them up with the police. You have to first go to the trademarks authorities and get an opinion of the registrar of trademarks, which opinion takes about a week or 10 days. So the goods have disappeared in 15 minutes. What to talk of 10 days? So that section 115(4) is something which has been very troublesome. We've talked about it again and again, but I think the government needs to do something about that section. Thank you. Thank you very much.